Welcome to our Regulations video series. I'm Laura, your Customer Success Manager, here to guide you through the Florida Security of Communications Act and its key compliance requirements for businesses operating online. The FSCA is Florida's wiretapping law, enacted in 1969. It prohibits intercepting or recording any wire, oral or electronic communication unless all parties consent first. Courts are now applying this decades-old law to modern website tools like session replay, chatbots, and tracking pixels, making it a major source of litigation risk for website owners. Here are the key dates. The FSCA was enacted in 1969 and amended in 1988 to cover electronic communications. In 2021, Florida courts rejected early attempts to apply the law to session replay tools. But in March 2025, a federal court allowed claims over website tracking pixels to move forward in the Orlando health case, and that decision triggered a wave of website wiretapping lawsuits across Florida. This law applies to any business that intercepts or records communications involving people in Florida, including companies located outside the state whose websites are visited by Florida residents. It covers websites using session replay, live chat, chatbots, and tracking pixels, businesses recording customer calls, and the third-party vendors receiving that visitor data. The most important exemption is consent. Interceptions are lawful when all parties agree in advance. Other exemptions cover communication service providers acting in the ordinary course of business, authorized law enforcement activity, certain emergency communications, and devices that only track the movement of a person or object. Businesses must obtain consent from all parties before intercepting or recording any communication. That means inventorying every technology that captures visitor or customer communications, making sure third-party vendors don't receive the contents of those communications before consent, announcing call and chat recording up front, and documenting when and how consent was collected. Website owners should obtain prior, informed opt-in consent before non-essential tracking technologies start running. Consent gathered after tracking has already begun may not protect you. Display a notice before live chat and chatbot sessions. Block third-party scripts until consent is given. Disclose your tracking tools and vendors in the privacy policy. Honor opt-outs and keep time-stamped consent records as evidence. Courts focus on whether a technology captures the contents of a communication, like messages, form entries, and search terms, rather than mere metadata, so sensitive inputs carry the highest risk. Plaintiffs are also testing pen register theories against analytic scripts. Because damages apply per violation, exposure aggregates quickly across visitors, so review your vendor contracts carefully. Individuals have the right not to have their communications intercepted, disclosed, or used without consent. They can sue directly and recover actual damages, liquidated damages of $1,000 or $100 per day of violation, whichever is higher, plus punitive damages and attorney fees. They can also seek an injunction, and unlawfully intercepted communications are generally inadmissible in court. Criminal violations are a third-degree felony, punishable by up to 5 years in prison and a $5,000 fine. On the civil side, individuals in class actions can recover $1,000 or $100 per day per violation, whichever is higher, plus punitive damages and attorney fees. Website wiretapping filings under the FSCA have surged since 2025. Thank you for joining us. At Clym, we're here to help you navigate compliance with ease. Visit us at clym.io to learn more about our all-in-one digital compliance solution.